So I'm Clayton Johnson. I'm here with Squire. I work for our Squire Wealth Department. And I have Catherine Harrison here, who's one of the founding partners of Hundley and Harrison, a law firm that we do a lot of work with and does estate planning. Catherine and I have wanted to get together and do a presentation to the group, and so we're excited that there's interest. Excited that there's interest, and glad we can help out here. So what we're going to talk about today is financial planning is a component of it. And you notice here we're talking about maximizing your financial legacy, but really it's this topic of what is legacy planning and how can we prepare for our legacy. And there's multiple components to legacy planning. Oh, now it doesn't work. We practiced it, and now the button doesn't work.
Technology, I'm telling you.
It was just clicked out of it.
Okay.
And the basic essence of legacy planning is how do you want to be remembered? Okay. Now there's two big components of planning for legacy, and the first is what we'll refer to as the soft side of legacy planning. What type of vision, values do you want to convey to the next generation? And the second part, which we'll probably spend the bulk of our conversation today, is what specific tactical things can we do to preserve our assets, whether it's intangible or tangible assets. Catherine's going to talk about estate planning process and the elements of estate planning and how to preserve that legacy. But I want to start with that conversation, the soft side of legacy planning, to get an idea and an introduction into what this is. So we're going to start with what we call here the wealth planning pyramid. Okay. Before we can really get into the tactical, what should we do for your legacy plan or your estate plan, it helps all of us to be informed. What do we even want to accomplish? It's hard to know where to aim the arrow if you don't have the target, right? And so we like to start here at the top. What type of impact do you want to make, whether it's on your community, on your legacy, on your family? And then we move down that pyramid to a more tactical approach. What type of goals specifically do we have for our life, for our children, our grandchildren? It's so important to really get that general idea before you sit down with Catherine or Clayton and say, hey, we want to accomplish this with our investments, or we want our estate to do this. Because there are so many different trusts that can be set up, so many different investment strategies that can be implemented. Not every solution is going to be the same for every person, and it helps to just really know where you're starting out, a good starting point. One tool that might be helpful, you may be asking yourself, Clayton, okay, this is great. How do I get started? How do I figure out what my vision is if I don't have one? This is something that we use with a lot of our financial planning clients. We'll sit down and we'll go through a conversation about what's important to you about these categories. What's important to you about family? What's important to you about your interests and causes? Do you want to travel? Do you want to do this? Do you want, after you're gone, do you want your kids to continue to meet and have a reunion every year? And you want to set up some type of a fund or something like that to continue paying for family to get together? All relevant components of planning for your future and for your legacy. And then this is a helpful guide, and I've got a couple of printouts here, and we'll send a PDF to you following up this meeting. A helpful guide as you are considering how do we transfer our wealth. Some of us in this room may be closer to that phase in life where we may be transferring wealth on to the next generation. Some of us may be starting out, but it's a helpful guide to help us identify, okay, what does the transfer of your wealth matter? Why does it matter to you? What can you do in your lifetime to help prepare for that event? Who will ultimately benefit from receiving your wealth? What should everyone involved know and when? That's an important one. Phase 4, the communication plan. You could have this amazing plan and not a single person in the world knows what you're planning to do, right? And then the last is, what do we need to do to implement that plan? So Kathy's going to get into some of these elements. She's not going to necessarily address them specifically, but largely into, okay, how do we plan for that? What estate plan do we need in place? What is it that you need as part of your estate plan to prepare for the future? So I'm going to turn it over to Catherine to the clicker works.
Okay.
Advance.
That's the one.
Back.
Okay, ready to go. All right, hi everybody. Hope you're enjoying your pizza. My name is Catherine Harrison. As Clayton said, I run the estate planning practice group at my firm, Hundley and Harrison. We're a boutique law firm. We have an office here in Provo. This is Orem, Provo and South Jordan, so we can help you other place you are or travel. Sometimes I travel whenever my clients can't get to me. Sometimes I go to nursing homes or hospitals, you know, dealing with end-of-life care issues. I'll show up. So I love estate planning. It is the best area of the law. Usually because all my clients are happy, and they're mostly concerned with how to distribute and to protect their assets and how to distribute to people they love. So I can't think of a better area of law because there's no contention usually, unless we're talking about, you know, who gets the Tinker toys. Anyway, all right, so do you have an estate? Now this is my basic estate planning kind of lecture here, so if we have more specific questions about different types of estate, raise your hand and let's talk about it. But the most basic question is, do you have an estate? And the answer is yes, you do. Anything that you own is part of your estate. It's comprised of usually your home, your personal possessions, your bank accounts, your life insurance policies, retirement accounts, vehicles, business, all that stuff is your estate. And by the way, all of this whole slideshow kind of follows this little infographic here. So if I'm going too fast for you, most of that information is said on my little infographic. So you have an estate, congratulations. What is an estate plan, right? An estate plan is a series of 4 major documents that help you first distribute your wealth to your family efficiently, and then second, before you pass away, they can assist your family taking care of you if you become incapacitated, right? So you provide for your family and you make sure your loved ones don't inherit a complicated mess. Let me go back. If you don't have an estate plan, does anybody know what it's called that you have to go through, your family has to go through in order to be able to distribute your property?
Probate.
Probate, that's right. Does anybody in this room have experience with probate? It's not amazing. It's not the best thing in the world. Okay, so probate, this is the elephant in the room that's not on my slides, but I want to talk about it. Probate is a court-administered process whereby everything that's owned in your individual name is documented, itemized, overseen by a judge, and then distributed with court oversight. If that doesn't sound awful, then let me go a little bit further. It's quite expensive to hire an attorney to help you go through it, way more than it does than just doing an estate plan. It is very time intensive. It will take you usually a minimum of 3 to 4 months, probably average 6 months to get through the probate process before you can even distribute anything. And it's also all public. Many of my younger clients don't care that it's public, and I'm going to tell you why you should care. You should care if it's public because we have predators that love to comb court websites. And this just happened to me 2 weeks ago. Somebody was combing. I had just finished a probate matter for a client. And she gets a letter in the mail saying, you are past due on $60,000. And if you don't pay within 2 weeks, we're going to foreclose on your home. She sends it to me just in tears. How this is a creditor that came for probate. How could this happen? It's from the IRS. And so I looked it up and I said, this happens in probate sometimes. This is a predator. This is fake. But it's preying on people who had to go through probate in the first place, right? So we want to avoid that. That's another stress we don't want to deal with, okay? So the most basic, biggest documents in an estate plan are a trust and a will. Does anybody know the difference? I'm going to tell you. Okay, a trust is a living document that completely avoids probate. Congratulations, yay. It creates a plan in case you're incapacitated. It lets you name somebody to be able to distribute money to your children or whatever other beneficiaries you have. And it connects to all the other estate plan documents, okay? The trust is the most important part of your estate plan. Everything that's in it skips probate, right? It follows your social security number and it moves along with you. And it's wonderful. And the type of trust I'm talking about today is the most easy trust to manage. You don't even file new tax documents for it. That's how fun it is. A will governs anything that's in your personal name. So it It would govern anything that's not titled. That is where you name guardian of your the guardian of your children if you have minor kids, okay? And you can decide who receives your assets. But in my case, when I do wills, I do what's called a pour over will that says you only have one beneficiary, and that is your trust. Now, something that many people don't know, they say, oh, do we need a trust or do we need a will? Do they do the same thing? No, they don't. A will is a good catch-all provision because it pushes it into the trust, but a will still has to be probated. So that's no fun. Why would you go get an estate plan if you still have to do through probate? You're double dipping. You're paying twice. So I use what's called a pour over will. Most estate planning attorneys recommend a pour over will as a safety net. So say somebody comes into my office and say, we're okay, we have a trust made in 1998. It's become completely stale. And by that I mean it doesn't own anything. They live in a different house. They don't have the same cars. They don't have the same bank accounts. And so the trust doesn't own anything. So guess what's going to govern? The will. But the will says everything goes into the trust. So safety net. Does that make sense? Does anyone have any questions on a trust versus a will? You guys are so easy. Maybe it's because you're.
I have a question. Jennifer.
Yes, go
Maybe
ahead.
you're going to get into this in your presentation. Because oftentimes when I'm meeting with clients, I run into this, well, at what point do I need to consider a trust?
Oh, good question. Yes.
Because if you're just starting out and you're just graduated college, now it doesn't look like we have anyone in the room that meets that criteria, maybe a trust isn't necessary yet. Right? You might disagree. Maybe you can speak to that.
Yeah.
What would constitute needing, okay, it's time to get a trust set up and time to look.
Yeah, let me talk to you about the triggers, okay? The first trigger is owning real estate. If you own real property, you need a trust because you will be going through probate, no matter what. Number two, if you have personal property of over $100,000, which having real property would push you there, property over $100,000, you will be going through probate. Number three, if you have minor children and you need to contend with naming a guardian and being able to fund, your children's lifestyle and not be tied up, you need a trust. Okay, so those are my three big triggers. If you don't own any property, if you have under $100,000 in assets and you don't have any kids or they're all over the age of 18, then we'll talk about a small estate affidavit, but that's where we are. And most people, once they own property, they're there. Okay. All right. Revocables. We just talked about all this. Okay. So to recap, a revocable trust avoids probate. You control the distribution of your assets. You name a successor trustee. That's the manager of your trust to be able to distribute everything. And the successor trustee also manages your assets if you're incapacitated. So that means you're alive. You can't make all the decisions for you, and so that they manage your trust for you. We talked about the pour over will, how you nominate guardians for your children, and you also nominate a personal representative to control your assets. In a trust and a will, I usually make those the same people because they're doing the exact same job, right? Just pouring it into the trust to be able to distribute. Okay. All right. The trust and the will, they really get their day in the sun when you've passed away. They give you the ability to distribute efficiently. The other two documents in the estate plan, the most important documents, are the Advanced Healthcare Directive and the Power of Attorney. Those really come in the sun and they get to shine when you're still alive, but you've become incapacitated somehow. That could be you get cancer, you have some type of Alzheimer's or dementia, you get in a car accident, you have traumatic brain injury. Now, healthy people don't often contemplate those things. They say it's not going to happen to me, but oftentimes it does. An Advanced Healthcare Directive allows you to name an agent to make medical decisions on your behalf if you become incapacitated. Now, when I say incapacitated, that could be permanently incapacitated or it could be temporarily incapacitated. You could have, I don't know, TMI. When I have my babies, I have 3 kids, and when I get pregnant, I get something called hyperemesis gravidarum, where you throw up 20 times a day. Okay? So I lose a lot of weight, I can't function very well, and in that situation, I could activate my Advanced Healthcare Directive and have my husband take care of some of my medical decisions for me. I didn't do that because I'm a control freak, but we worked it out in the end. Durable Power of Attorney is another legal document that deals with legal and financial decisions. Okay, so you name an agent to be able to make legal financial decisions for you. That could be what to do with your investments. That could be paying your mortgage. That could be settling legal claims for you. And they can do all that with the power of attorney. Now, just really briefly, I'm going to talk about why these are so great to have during the period of incapacity, as opposed to a guardianship and conservatorship. So if you look at this little handout I've given you, I don't have a slide on it, so I'm cheating on Clayton a little bit. But you see, what's the difference between having a power of attorney or a guardianship and conservatorship? There's so much. If you don't have a valid power of attorney or advanced healthcare directive, I get these calls all the time from clients. Mom or dad has become incapacitated somehow. We need to be able to make decisions for them. The only way to do that without a power of attorney and advanced healthcare directive is to go to court and get a guardianship over them. And that you're going to probate court. You're going in front of a judge. You go to multiple hearings. You have to show evidence of incapacity with a doctor's note. And so reading between the lines here, it is long, it is expensive, and it requires court oversight. Again, so in a cost-benefit analysis here, if the advanced healthcare directive and power of attorneys are so relatively cheap, you know, it's like $200 per document, versus if you come in and say we have to do guardianship, it's like $2,500, and it takes months to get there, right? So we want to avoid guardianships completely. And I've given you the pros and cons list here. We don't want the court overseeing us. We don't want the court to see into our finances. We don't want the court to we don't want the court in our lives. You know what I mean? So read through this and then consider. Yes.
Is there a difference between power of attorney and the successor, whatever that
Successor trustee. Yes, that's a great question. Okay, so the successor trustee manages assets that are within the trust. Okay, it just manages trust stuff. Okay, a power of attorney comes into play when you are alive, right? And it manages personal like stuff that's still in your individual name. Right. So, for instance, now we may be getting a little bit in the weeds here, but if I had a client that was Clayton's client too, and Clayton wanted to make some moves with their portfolio, that is done outside the estate plan, and so he would need to have a valid power of attorney on file to let the agent talk to him to make those decisions. The trustee could not do that because these accounts, any retirement accounts, should be owned in a person's individual name. And then they fall into the trust later with a transfer on death or payable on death beneficiary. Does that make sense? So that's kind of the designation there. It's a really good question though, because some people get confused about it.
Is it wise to have different people, different children or whatever, be the successor and the different person have the power of attorney?
Well, that depends on how much you trust your kids. Right? So I see some families that will diversify because they want to have a certain checks and balances within their family. The most efficient way, honestly, is to keep it the same person because they're dealing with all the trust money and then they're dealing with the power of attorney dealing with maybe like retirement accounts. So if you trust them, then that's great. But if you want to create some checks and balances, which is also very common for families, then you can place other people there. Okay? Any other questions? Yes.
The transfer on death element of that you were speaking to.
Yes.
Can you go more into that? Now, like say, if I was to say, upon death, I want you to do this, that, and the other.
Right. So
not to have that power of attorney so much while I'm alive and kicking and my brain's working good.
Right.
You understand?
With retirement accounts? Is that what you mean, or just in general?
Or the whole portfolio.
So the trust is where we designate what we want distribution to look like, right? We're going to say so-and-so gets this much, so-and-so gets this much. This kid was a knucklehead, so we're giving him less. We walk through in the trust what we want distribution to look like. So the big goal for me is we make one central funnel, and that is the trust, and distribution follows the trust. That's why, you know, when we deal with the power of attorney, if, you know, somebody's managing, Clayton or Dwayne is managing their assets, the primary payable on death beneficiary of a retirement account is either the spouse or falls into the trust so that the trust can distribute according to whatever you've outlined, right? So you have a good central plan. Did that answer your question?
I think so.
Okay. Yes, sir.
Sounds to me like power of attorney, person assigned has to have some legal knowledge, has to know how to interface with people.
Not so much.
He's got some responsibility, it looks like, and if they aren't mentally capable of handling that,
Right.
might be a carpenter, not a person that handles legal matters. How do you recognize that in an individual?
Well, what I would say is you're looking for somebody that just has good judgment. You're not an attorney, you guys aren't attorneys, and yet you're making financial decisions. You're working with Clayton or Dwayne or Camille, whoever, and you're making these financial decisions about where you're moving your money, and you don't necessarily need a law degree to do it. That being said, if you ever want to hire a professional power of attorney in fact, to make these decisions, you can. But I always tell my clients, I have a really high hourly rate, and these aren't attorney issues, and so I can charge you them, but I kind of feel bad doing so, because I know you probably have at least, you have a kid that's not a knucklehead, that can work through these issues, and you call if you have a financial planner, you call that financial planner, and they're gonna give you really sound advice, right? So that's what I'd say. And as an aside, the power of attorney, it dies when you pass away. So there are some people that say, oh, I'm gonna use my power of attorney after mom or dad pass away and get into their bank account. Can't do that. Power of attorney expires when you expire. That's when the trustee steps in, and it's their show. Thanks for the question. Any other questions?
Great question.
Yeah, really good questions.
I do have one
Yes,
question,
go ahead.
because I think this is born out of a conversation that I have with clients where they think that because they're married, they can make medical decisions for their spouse, which is a common misconception.
Yep.
Right?
Yep.
And so sometimes a client comes to us and say, well, why do I need this advanced healthcare directive? My spouse and I know exactly what I want to do it. Well, is it true, is my question, that you need an advanced healthcare directive even if you have spouses who are aligned and to show the appropriate person, yeah, I can make these medical decisions.
Right. You really do. You really do need an advanced healthcare directive, even if you're married and you like your spouse. So there are a few things to consider here. One, I had the great opportunity to be a divorce attorney for 5 years, and not all marriages are happy. Let's just put it like that. And you wouldn't trust your spouse with those decisions. Now, if that's not our problem, great. Our next, I know. Okay. Thank you. No one laughs at my jokes. Okay. The next big problem you have is in the advanced healthcare directive, that's where you designate your end of life care decisions. So that's where you say whether or not you want to be maintained artificial life support. Husband may know so-and-so doesn't want to be maintained artificial life support, but it's not in writing. And so guess what? Those doctors are going to try over and over and over again. They're going to put you on all the artificial life support. They're going to continue the CPR, even if you don't want it, if it's not written down. You want it written down, yes.
So does that allow you to have like 2 people listed? Because say that you have it as your husband and you're both in a car accident.
Yes,
And neither of you. So does it have like
Yes.
this and then this person?
absolutely. I like 3. So I've done 4 before. One time I did 5. It really took up a lot of pages. But anyway, you list them, but a distinction between power of attorney and advanced healthcare directive is you can't have co-agents because it creates potential conflict, right? So you list one and then the other and then the other. Whereas when you're working with a trust or a will, you can make co-trustees. Anyway, we have a long list. Okay, good question. Any other questions on this? I'm really working this little piece of technology.
Great.
Okay, what?
You skipped. Just as you said that.
Oh, okay.
That's what you want.
All right, schedule of assets and personal property letter. This is the bonus material inside of a good estate plan. There are some attorneys you'll go to and they'll write you an estate plan. It looks really pretty, and then you open it up and you see a blank schedule of assets. I don't know about you, but I don't know how that's helpful. You know what I mean? Like if you're a kid and you're looking at it and you say, I don't know where any of mom and dad's stuff, where is it? Where's all the stuff, right? Where do I look? Do I call up Zions and MacU and Bank of America and where are their bank accounts? When you do an estate plan, whether with me or anybody else, make sure they're giving you a complete schedule of assets. They say, okay, we have 3 accounts here at Chase. We have 1 account here. This is where we own all our real property. These are our retirement accounts. Even if they're not owned by the trust, they're there. So you know who you need to call in order to get this stuff distributed. You want a full schedule of assets as a roadmap for your kids, so they're not playing needle in a haystack. Okay? So that is a sign of a good estate plan. The next is a personal property letter. This, again, is bonus material. I call it a Schedule B. This is where you say personal possessions. Now, I made a joke, nobody laughed about, it's fine, about Tinker Toys. You'd be surprised about the number of fights I see on personal property because of sentimentality, right? It can be a fight about Tinker Toys or the spoon collection or the piano or the, the one time it was a ceramic frog. I kid you not, there were many hours spent on the phone about a ceramic frog. So list your personal property if you have specific gifts to give, right? My daughter's Lillian. Lillian gets the piano. Benson gets the train set. You go through so you're avoiding fights, right? And those elements, all 6 of those elements, that's a full standard family estate plan, okay? It's a little bit like drinking from a fire hose. So I bet you got some of it. If you didn't get all of it, then I have handout. You can look at it later. Any questions about the legal aspects of estate planning?
I do have a question.
Yes.
We are talking about a revocable, what is it?
A revocable trust.
Okay, what is an irrevocable trust?
Great question. Irrevocable means you can't change it.
Okay.
Revocable means, you come to me and you have young kids, and we lay out all we want to do. Your brother's going to be the guardian and the trustee. But your kids, they're suddenly 30. Let's do an amendment, which is a change, and make the kid the new trustee, and we don't need a guardian, and we make all these changes. The most popular trust, which is when I was talking about living trust, because you're able to change it, you're able to manage it on your own, you don't have to pay any more taxes, and once you pass away, that's when it becomes irrevocable.
Well, if it's you and your spouse, and you have the trust, and one of you passes away,
Good question.
then what happens?
That's a hot topic. Okay, so some people, my clients, I give them the option. Would you like this trust to be irrevocable once the first spouse passes away? That's the worst. Second, do you want it to be still completely revocable and amendable? That's also problematic because what if they find, a new spouse? Or third, somewhere in the middle. The middle I usually recommend is surviving spouse cannot change the distribution or trustees of the trust unless they get the approval of the next successor trustee, which is probably, Jimmy the son or, Gianna the daughter or something. Or the beneficiaries have to vote. Yes, sir.
Is that written in the trust,
Yes.
what you just said?
Yes. It's written in mine. I don't know about the other people, but it's in mine. That's my favorite way to do it.
Okay,
Yes.
so someone to cooperate with the existing successor, they have to have permission from a second
Yes.
assessor in order to make that change.
Yeah, and I think it's a really good middle ground. You still have that flexibility, but you have the oversight, those checks and balances from the next successor trustee. So we're not all giving it to new spouse who's then going to give it to the animal society and cut out all the kids, right? Which
Yeah.
I've seen.
So that particular clause is not automatically in a trust, it's something you have to make sure is put into the trust?
Yes.
Okay.
Yes, absolutely. One thing we didn't talk about, actually, I'm gonna let you do that, the step up in basis. I was gonna talk about it as part of real estate, but I think you're gonna hit it. But that is another reason trusts are great. So that's good foreshadowing for Clayton.
Well, and Jim, to your question about irrevocable trust, that I've seen them used well when people are above the exemption amount. So there's an estate tax exemption amount, and I forget the exact number.
12.95.
$12.95 million, okay? And so some people whose net worth is above that, spouses combined, so 12.95 times 2, they want to get assets out of their estate before they die, so they're not subject to the estate tax. And so they use their irrevocable trust because technically they can still have some control over it to a certain degree, make some decisions about it, but it's out of their estate to the beneficiary. And so it's an estate planning tactic for reducing taxes.
Right. One more thing on real estate as far as a step up in basis, I might be stealing your thunder here,
You're fine.
is that a revocable trust makes it a lot easier to use your election on your estate plan. And I don't know if you were going to talk about this, but this is the example that I give. My grandparents built a house in Palo Alto, California in like 1955 for $25 million. $25 million, $25,000. It was very nice. $25,000, okay? $25,000 they built in 1955, okay? They passed away in about 2016. They had lived in that house their entire lives. So their increase in equity, in long-term equity, was enormous. It was sold for $2.8 million. When you have a trust, you get what's called a step-up in basis. So you can bring up let me back up. If they didn't have a trust, they would be taxed on the entirety of that growth, right? 25,000 to 2.8 million. The tax burden would have been enormous, right? Since you have the trust makes it a lot easier to take an election and you push that equity mark up to the date of death. So suddenly, instead of paying taxes on 25,000 to 2.8 million, it's like, 2.7 million to 2.8 million. Your tax burden has been minimized substantially, right? And so that is one of the really great aspects of having a trust. Just makes it quite a lot of it easier to do that. Were you going to cover that?
I was going to cover it more on the investment side than the real estate
Okay,
side.
all right. Then this is a great opportunity to switch.
Yeah.
Okay.
Okay.
Oh, yeah, hold on. You don't get it yet. Wait, you can't hold it. Okay. All right, right here. Yes.
Yeah. So right now, for example, I have with my spouse to have like a revocable living trust.
Yes.
And then my spouse passed away. So can I keep the trust if I never marry again? There's no second spouse, anything. So can I just keep that trust? Or I
Probably.
have to?
No, you probably can. I haven't seen your trust, but if it were a trust that I had drafted, it should survive and you should be able to function within it.
Yeah, because I remember they always say if somehow like either one pass away, the other one just like inherit everything.
Yes. And that's the way it should be. Again, not seeing your trust, my answer is probably, not yes, so nobody comes after me. I love liability. Okay. Yes, sir, in the back.
Yeah, I probably need to update my mind, but I thought the step-up basis applied no matter what, when someone inherited property, whether it's in the trust or not. Am I wrong?
Not necessarily. There are some things that you can do to really mess up your situation, right? So you could be transferring it to your wife, and then your wife, sells it or something like that, and then you lose that equity, or you put your kid on the house, and they will be stuck with it. And so there are just all these pitfalls that you can come into, and the trust just makes it a lot cleaner and lets that transfer happen. And it's possible. It's just you're weaving through a lot of pitfalls. And
Okay.
accountants love to talk about this. Aren't you a former accountant? No. Okay, yes, sir.
Two questions. You were talking about taking out your money before you die, or say you're gonna die, but you have the trust to say in words, I want the money out before I die. I'm gonna die in a week. I want it to come out in 3 days. Does that help you to avoid tax?
Not necessarily. I mean, I guess
You
I
were
don't.
talking something to that effect. Maybe I misunderstood, but.
Well, you don't need to take your money out before you die. Hopefully, what the trust does for you is you're minimizing your estate tax obligation. If the type of trust this is that that's like a $12.95 million mark. I do other trusts that's a $25 million mark to prevent any type of estate tax. But you don't need to move it before you die, because the successor trustee can step in and function with the trust just with a new tax ID number. So the trust doesn't die when you die.
Oh, well, I understood you to say that the little loophole, if you will, was that you can take it out before you die, and then you avoid tax.
For real estate? Oh, like.
As the estate.
I'm not sure if that's what I said, but I can comment on that if you'd like. What you want to do for estate tax and any type of tax liability is look at your markers. If you're close to $12.95 million, you can start giving partitioned gifts to people out of the trust to reduce your liability. Right now, I think it's like $17,000 a year. Is that correct? Does anybody know?
It's close to that.
I think it's between
I don't
15 and
remember the
17,000. You can give, if you can distribute your money that way to reduce your limit. It doesn't have to leave the trust in order for you to, avoid tax right before you pass away, because most of us can't plan our deaths that well.
So I think I can jump into, because I think it was something that I said. that
Maybe
made
you.
Think of that.
Yeah.
So you've got multiple taxes out there in the world because the IRS likes their money, right? You have your ordinary income tax that you're gonna pay no matter what. And then if you die with assets over a certain amount, which is like this 25 million, on top of the ordinary income tax, the IRS comes in and says, because you're rich, we're gonna take more tax, and they call it the estate tax. And so what I was referencing is if you're close to that threshold, there's ways to get assets out of your estate, so you stay below that threshold and you avoid the extra double tax from the IRS.
And when we were talking in one of our conversations about donating money when you turn 71, donating money to the church,
Yeah. Through a qualified charitable distribution.
which reduces the amount of taxation that you have to pay, right?
Yes,
Right.
yeah.
Okay, so my second question to you was, I was told a while back, maybe I just misunderstood, and I do that quite often, is that in Utah, when you receive a inheritance, we'll call it, that it's non-taxable, is that correct?
Depends on how much it is. Yes, usually it's generally non-taxable. If it's part of a greater estate that's like over 25 million and they didn't categorize it, then they could come back and claw back. But the general rule is it is not taxable in the state of Utah.
So if I have 10 million,
Yeah, easy.
and it's like, all right.
Yep.
Jordan, my son and
Enjoy.
daughter, here's your money.
Yep. But you can't,
Non-taxable to them.
if you give it to them while you're still alive, it is taxable. If you do it at death as a bequeathal, then it is not taxable.
Oh,
Because
Cool.
while you're still alive, you have like a $17,000 per year limit. And then you're gonna be hit with substantial taxes.
We don't have 10 million, so I think we're okay.
There's no problem. I would love to have some of these problems in my clients, no.
And as long as you stay below that exemption, all you have to do is file a gift tax return, but you're technically not paying any tax on
Right.
that. So yeah, even if you gifted 10 million, you'd have to fill out a special form, a gift tax, and though you wouldn't pay any tax. It's just an informational return. Until you get over the threshold. If you gave 30 million away to your son, then yes, you pay a gift tax, and it would be substantial.
Okay, I think, any other questions? I feel like I went over.
No, you
Sorry.
didn't. This is great.
Okay,
This is awesome.
Clayton's gonna do it.
And I thought of when you mentioned this personal property letter, in my family, I don't know if we have this, but we have a book. It's like a table in our family room, but it's in the shape of a book, and the spine pulls out into a drawer.
People want that.
And my sister is adamant that she gets that item. And so she's already expressed, like, nobody gets this bookcase table but me, but I'm not sure if it's in the thing, so I
Do you
might
like
just.
your sister or your kids? What's the fun?
Yeah, it's pretty ugly. I don't want it, so. Okay, so Catherine, thank you. That was fantastic. So I'm going to get into a few things related to investments and the financial side when it comes to some legacy planning. And it's important to understand that your wealth can really only go three places, either to your heirs, to a charity, or to our very favorite, the government or the IRS, right? Now, I can venture to say that most of us probably want to reduce what goes here and increase what goes to these other two, depending on the goals that you have. You may say, I want it all to go to my heirs, or you may say, they were spoiled rotten, I want it to all go to charity, right? That is going to be something that you determine. But when we're doing planning, we're looking at those three ways. How to reduce typically, what goes to the IRS. We talked about some of that as far as how do we get things out of the state if we're above the state thresholds, and pass that wealth on to heirs and charity, okay? So what I want to talk about, because this is a really, really important part of investment planning, is asset location really matters. And what I mean by that, an asset location in the financial planning world means where are you putting your assets or your investments, okay? So this may seem like an elementary review, but I'm going to introduce a few of the accounts that we typically see. You typically see taxable accounts. Now this is where Catherine was talking about like a revocable trust. If you have a revocable trust and you have an investment brokerage account with assets that are in that trust, it's going to be typically taxable. Now to Jim's question, if it's an irrevocable trust, it actually has its own tax rules, and typically irrevocable trusts have higher tax rates than a revocable trust, because the revocable trust, they're just counting that as part of your household when you're taxed, okay? Then you have tax deferred accounts. These are your traditional 401ks, your traditional IRAs, and then tax-free accounts. These are your Roth IRAs and your Roth 401ks. And what investments we put in each of these makes a big difference on your overall wealth growth, okay? So I've got a busy screen here. I'm going to talk about a few things as we assimilate the information here, okay? So I'm going to talk about a few different types of investments. So you've probably heard of bonds and fixed income. That's going to be represented here in these intermediate investment grade bonds. So bonds and fixed income, typically they have a lower expected return in the long run. They're more your steady eddy investments, but they're also less tax efficient. They usually pay out interest, which when you receive interest in that year, you pay it at ordinary income tax rates, okay? So depending on your tax bracket, you're going to be paying typically the highest tax rate on interest that comes from bonds, okay? Then you have stocks and equities, and I'm happy, you can take pictures by all means, but I will also send this slide deck. So you have the PowerPoint as well, okay? And you're fine with that, right, Catherine, if I send your slides as well? Mm-hmm. Yeah, we'll send a follow-up. We'll have some of our forms and PDFs, so you can kind of take that all with you. And then you have stocks or equities. Typically, your stocks, depending on what part of the market they're exposed to, large, small, international, they're going to have differing levels of expected return. Typically, they're higher than bonds, and they're more efficient in their tax, how they're taxed. So you're not typically getting interest from your stocks. You may get dividends. Dividends are you're going to pay ordinary income tax at, but a lot of the growth of your stocks come from capital gains, and you don't pay the capital gains tax until you sell those investments, okay? So you can see here, we'll use the example of US total stock market. This is like your Apples, your Facebooks, your Netflix, the big, large companies. They have moderate to high return, and they're moderately high in their efficiency. Now, you may heard of exchange traded funds or ETFs and mutual funds. Typically, ETFs are much more tax efficient than mutual funds. So in a taxable account that's going to be subject to the capital gains that happen in the fund, it's good to have ETFs because you're going to reduce your tax impact, okay? And then you've got municipals. These are typically government fixed income, and they provide very high efficient, they're high efficiency in taxes. You typically get a tax break if you invest in municipal bonds, but their return's pretty low. You're not taking a lot of risk in these investments, okay? And then the last one I want to mention is alternative lending or alternatives. These are a little less common to see in portfolios, but you're going to have access to alternatives in your portfolio. They're doing things like alternative lending, where you can invest in a fund that's lending out to businesses or consumers, and if they pay back, you're getting that. They're very inefficient from a tax perspective, but they have a place in a portfolio if you're worried about how your investments are all working together. So alternatives, if the market's going up, they're not necessarily going to go up. If the market's going down, they may not necessarily go down. So they have a low correlation to what's happening in the market. So especially as you're near the end of your life, alternatives make a really good option for leveling out the overall volatility or ups and downs of your portfolio, okay? So I went through that really fast, and I'm sure if you've got questions about specific investment types and their behaviors, I'm happy to answer them. But what I want to talk about is, once we've identified the type of investments that are in your portfolio, and when I say portfolio, I mean all of your accounts together, then we decide, okay, which type of account does it go into? So we use this dark blue as an example. This represents Roth 401ks, Roth IRAs. Because Roth IRAs grow tax-free, meaning any money that's in that Roth IRA, You could have it there for 30 years. When you pull it out 30 years later, you pay no tax on the distributions. It's fantastic, right? Roth IRAs are a really great part of a portfolio. And so for that reason, we typically want investments that have higher expected return so that they're going to grow significantly and you don't have to pay tax on any of that capital gain. Okay? Yes.
Roth, from my understanding, the money is taxed before you invest.
Yes.
That's why it's not taxed at the end.
Correct.
Okay.
Yes. That's an important.
Even if you just had a small amount or a smaller amount in the Roth that you pay tax into, and then you say triple your small amount, you don't have to pay from there to there. Really?
You do not, really,
Huh.
really, which is why they're great, right? So to your point, yes, they're considered tax as they go in. And what that means is, say Squire pays me a salary and I've got $5,000 left over for the month, okay? I've technically already paid tax on it because it came out when my payroll paid me. I could put that 5,000, throw it into a Roth IRA. They're not going to tax me again putting it in the Roth IRA. It just goes in. And then from there on forward, it's totally tax-free. Okay?
But you have to pay on the interest it earns, right?
Nope.
No.
That's what he's saying?
You pay no tax.
How does that work?
Because the government got the tax for it up front. When you got paid and you paid your payroll tax and you paid everything, the government got that money now, and the government likes to get their money now.
But the interest is new money.
Yeah, but it's in a Roth. It's protected from taxes
way the
ever
laws
again in the
are-
future.
Just the way the law
You don't
is.
pay
I don't-
tax on it.
Doesn't make any sense, but that's what.
Well, it might help if I contrast it with a tax deferred or a traditional, okay? So say I've got that same $5,000 and I decide to put it into a traditional IRA instead of a Roth IRA. When I put it into traditional IRA and I go to file my taxes this year, on my taxes, I say, I put $5,000 into my traditional IRA, and the government says, good job, we're going to give you a tax deduction for that contribution. And so I'm getting a tax break up front, putting money into traditional IRA. But what happens is, as that money grows, say I put that $5,000 and 30 years later, it's now $50,000. When I pull that money out, and I pull that $50,000 out, all 50,000 of that is going to be considered ordinary income to me. So I got a tax break up front, which was nice, but later I'm going to have to pay taxes on that. And so really the decision between which one of these accounts you use comes down to what tax bracket are you in now and what tax bracket you expect to be in when you're pulling money out of it. Did that help put some context around it? Sometimes Roth IRAs sound too good to be true, and there's a lot of people saying, well, the government's not, they're gonna wisen up and they're gonna get rid of Roth IRAs. It was on the chopping block, or at least it was a discussion in the last year or so, and everybody, it was jointly approved to keep them going by both sides, both Republican, Democrat, because they get their money up front and they want the money now because they're in dire straits, right? They want the money they can get now. Any other questions about that? Okay, so for that reason, because you don't pay interest and you don't pay any taxes on the growth, we like really high growth things in Roth accounts, okay? And same with this alternative lending, because they're very tax inefficient, that doesn't matter in a Roth. If they're tax inefficient inside a Roth IRA, it doesn't matter, I don't pay taxes on it anyway. Okay, and then next we look at, down here in the bottom right, you got your, in the middle here, you got your, we'll go to taxable, sorry, you got your taxable accounts. These are your revocable trusts, they're your joint accounts, savings accounts, checkings accounts, CDs, all that kind of thing. They're taxable. The interest you make in that year, you're paying tax on. So you want your most efficient tax products to go in there, like your municipals or your US stock market investments, because they're not going to pay as many dividends out. What happens here in the taxable accounts is you're not paying any tax on the growth until you sell it. So if I have a taxable account, I throw $5,000 in, it grows to $50,000. I sell those stocks for $50,000 and I use it to buy a new car. The difference between $5,000 and $5,000 is what we call capital gains. I'm paying tax on that $45,000 at taxable gains rates. And if I've held it for my investment for over a year, it's considered long-term capital gains, and that's typically a lower or better amount than ordinary income rates. Okay, and then lastly, we have our traditional accounts, and we like to put things in here like intermediate investment grade bonds that are not very tax efficient, but they're also not high growth. Okay, and so the message I'm hoping to convey here is that when we're looking at our portfolios and our investments, we want a big picture. You don't want to look at a specific account in isolation and say, well, my Roth IRA is doing really well, my traditional IRA is not doing as well, because you're specifically putting certain investments in certain type of accounts that are not always going to behave the same and have the same interest rates and growth rates.
Is that what you refer to as putting your eggs in different baskets, or diversification, or that you're just showing the difference between a traditional and a Roth and an intermediate?
It's a little bit different than the diversification discussion.
Clayton.
Yes.
So the difference, what he's talking about here is reducing your overall tax liability, right? So improving your overall return by putting the assets in certain locations so that return is maximized and your taxes are minimized. Versus diversification says, out of your whole portfolio, we need a certain amount of your assets in large company stocks. We need some of them in small company stocks. So there's those are two distinct components, right? Yeah. One's asset, what assets should we be buying? The other one is how can we minimize our overall tax liability?
Yeah. Thanks. Yeah, Dwayne, thank you for that. So
there's another question right here.
Oh, yeah.
This to me is complicated. I'm not smart enough to understand large cap, small cap, those are hats.
Right.
To me, it isn't money. So all of this kind of stuff sounds to me like this is something for a financial advisor to get involved with and advise me because I'm stupid.
Right.
I'll agree with everything, but
the
because you're stupid. I'm not gonna agree to that, but yes, you're right.
We specialize in.
So people that do it themselves, invest their own money, this is, and to be totally frank, not a lot of advisors do this either, right? It's we'll call it fairly common knowledge that you want your assets to go in the right places, but not all advisors are tax conscious and focused on the after-tax return. So when you're working with an advisor, you want to make sure that they're looking at this kind of a thing in tax location. But it's exceptionally difficult to get all this and figure this out on your own. And then how do you rebalance and do all that stuff? Yes.
Can I quickly ask you a question? When you say like the municipal, low return, high efficiency, do you mean that is pay higher tax?
No, high efficiency meaning you pay lower tax.
Lower tax? Yeah,
because a municipal bond, when you invest in it, typically the state or the country wants to say, thank you for investing your money. We're going to give you a tax break for investing in this municipal bond. So they give you tax breaks for investing in airports and stadiums and things like that, and projects that are going on in the state. Yeah. Okay. Yeah, and you're right. You're right, though. This can be fairly complicated. I just want to share, and I'll go back to the question you had too. So that diversification component, right? Usually we're representing this U.S. total stock market by hundreds or thousands of companies, right? Rather than just one company. You wouldn't want to build a portfolio and just have Apple representing your U.S. large cap. You'd want a lot of companies representing that. Okay. So this is the step up in basis that Catherine stole my thunder on. No, I'm kidding. So step up in basement. Did you have a question, Jim? Oh, okay. Step up in basis, I'm going to call the greatest tax break since sliced bread. Okay. Really just because it looks nice for the presentation. But the way the step up in basis works, let's say you have an asset. Okay. We're going to start here. And in Catherine's example, she used real estate. But let's say we have a stock. You inherited some Disney stock from your father, who bought that stock for the low price of $25 a share. And then in his life, that stock grew to $50 in value. If he sold that stock right before he died, going back to the question we had at the very beginning, he would have to pay this blue difference here, the growth of that stock. He had to pay the capital gain on that, okay? However, if he waited till death to pass on that asset, the IRS does something very nice called a step up in basis, and they say, okay, what's the value of that stock at their death? We're gonna consider that stock, that's gonna be what its basis was, what it was valued at, and you don't have to pay any tax on it. Okay, so when you're planning for legacy, if you have assets that have had significant growth, oftentimes it benefits you to hold on to that until after death so that your next of kin get a step up in basis and don't pay tax on
It
that
doesn't
property.
benefit you, it benefits them.
Yes, yeah, you're right. Yeah, I mean, if you do it before you die though, and you pay tax on it, then you are gonna pay more tax, but yeah, you're right.
Well, spouse can benefit from that.
Sure, yes, that's a good point too, doing it. So oftentimes it's good to put things in either a taxable account or a trust that you know is gonna have growth, and if you know you're gonna be passing it on to kids later, you're not so worried about the low cost of it, because you know you're gonna get that step up in basis. Okay, any,
Excuse me, yeah.
Yeah.
Does that only apply to stocks? For this one?
no, it doesn't only apply to stocks. It applies to real estate that we talked about, stocks, bonds. Help me out here, Dwayne, what other things apply to step up in basis besides investments and real estate? Those are the big ones.
I mean, yeah, real estate pretty much covers it, but
Yeah.
your house.
Yeah.
You may not associate that with it, you get a step up, to the
Yeah.
fair value of your house. It's all your assets basically get stepped up to the estimated fair market value.
Even investment properties,
Yes,
not just your residential.
everything you own.
This may be totally out of the ballpark, okay? We've got an LLC,
Uh-huh.
and I want to be able to, when I die, have my property passed to my kids. The step up all of a sudden becomes a problem to me in my mind. How does that work with an LLC? I die, the money's in the LLC, and my children are beneficiaries, but not in the LLC. What happens to that money? Is it stepped up, or do they inherit and pay taxes? What happens?
I recommend that you push your LLC interest into the trust. You can do that with something called an assignment of business interest that says the LLC is poured into the trust, and then this is what you want done with the LLC as a specific bequeathal.
The trust actually overrides the LLC?
No, it just takes over ownership.
On death.
on death.
Oh, it's the ownership.
And then it
The ownership.
distributes the way you want it to be distributed. Let's say,
So if
One
I
kid
die,
or-
my children then are actually, the LLC is part of the trust so they can inherit
right,
and have that step up?
Mhm.
Thank you.
What's an LLC?
Quick question. So that one LLC need to have an individual trust or the same trust?
you can put it into a family trust. You can have trusts own businesses, but you can push it into your family trust. It's really simple to do.
Go ahead. We're gonna-
Okay, yeah, that's a great question. Other questions? Time?
Yeah, some people, no, I'm saying it's about time, some
Yes.
people are planning to leave. so-
Yes, no, perfect, thank you, Dwayne. So, and this is the end. So just things to consider as you're considering estate plan and legacy. When was your estate plan last updated or reviewed? Catherine mentioned this. It's possible that your estate plan is stale, right? It's also possible if you did it many, many years ago, that laws have changed and it's needing updated. Are your listed beneficiaries still alive? Are they still your desired beneficiaries? Family dynamics change. And who was the beneficiary 10 years ago, you may not want to be the beneficiary now, right? Or even those who are acting as the trustee of your estate, those kind of things. We didn't get into this, but digital assets are a really hot topic right now. And if you look at the laws, technically even spouses don't have access to Apple Photos, Google Photos, things that you may want people to have access to. It's against the law, and Catherine can talk to more of this, for them to log in and collect that information after your death.
I've done
So-
probate for digital assets many times.
Yeah,
It seems silly, but it happens.
it does. And so and I've heard of attorneys who go to Apple and say, hey, we want this stuff, and Apple says, no, we're not giving it to you. So consider how you're planning for digital assets. In most cases with Google, Apple, these others, you're signing over your rights of ownership to these companies, and you don't no longer access. You're no longer the owner official legally of the photos.
Sorry, can you say a little bit more about Repeat, I don't really understand.
On digital assets?
Yeah.
Anything that you own that's digital, photos, things,
Blog.
logins, passwords, email, all that. That's becoming more and more valuable to us. Let's say you own an entire collection of DVDs and they're all saved on Amazon Prime or Apple Music or Apple TV or something like that. Those are all what we're talking about here.
Okay, got it.
Yeah.
Thank you.
Any pictures on the iCloud, right? If you have all your photos uploaded to the iCloud, it's with Apple, right? So that's a very common.
So you have to say specifically in your trust, all digital assets saved are permissible for Kathy to
But if it's,
access and.
if it's in the trust, it goes then to, right, whoever controls the trust. So she's the owner of the trust after your death, yeah, all that would transfer. And so what they're saying, Catherine's saying, if those aren't considered and haven't been put into the trust designated, then they have to go through probate.
Oh, okay.
Yeah.
Which we're trying to avoid your going through probate because that's a costly, timely, very time intensive process.
It's a complicated, digital assets is something I spend a lot of time on with my clients to talk about. How do we want to organize this to make sure that it's as streamlined as possible? Sometimes even if it's in the trust, there's some stickler tech companies that won't like Facebook won't let you in if it's in the trust. They won't, they require, their platform is similar to a retirement account where they require a transfer on death beneficiary within their platform. And so we talk about that as we go through it.
But nobody does that.
Nobody does it. I mean, I do it.
Oh, yeah. You're right,
I did it.
Okay, so time is up. If you have more questions, feel free to come to me or Catherine.
I think it's helpful for budgetary reasons. How much do you charge? How much do we charge? Just they know a ballpark.
Okay.
For
You go
me,
first.
a family estate plan, typical family estate plan that we talked about, ranges between $1,600 and $2,600. So that's based on your complexity of assets and complexity of distribution. So that's for estate planning on my side.
Yeah, and when we do financial planning for our clients, typically we're managing investments. We do a percentage of the assets we manage, which is roughly 1%. So our fee, if someone wants us to manage $1 million and do all the planning for them, we're charging 1%, well, 0.9% on that, on an annual basis. Okay. Thank you, everybody.
Yeah, thank you.
Appreciate everyone for coming out.
Thank you.
Yeah, we'll send all this material. So.
If you want to talk to any of the Squire advisors, Camille, myself, Dave Archibald's back here actually, and also Clayton, and of course Catherine, our star. Yeah.
No one has ever